Hello class, this video is for Chapter 12 in your book. Just wanted to touch on a couple of things. Chapter 12 moves into constitutional rights after arrest. The overall theme, if you will, is that post-arrest there are a series of procedures, substantive, a series of processes, both substantive and procedural, that police must follow in order for an arrest and an interrogation ultimately to be constitutional. The book starts with the interrogation process because that's oftentimes where things can go wrong. As a part of that interrogation process, the police have to make sure that the suspect, or the defendant at that point, is aware of their constitutional rights. Miranda is a big part of this process. Interestingly, in recent years, there's been a lot of discussion about Miranda maybe not being as necessary as it used to be. But in one way or the other, even though there are no magic words, the suspect needs to be notified that they have the right to remain silent, they have the right to an attorney, they have a right to confront witnesses against them, the entire Miranda set of guarantees. Oftentimes, suspects, or if you were to take them as far as make some generalities about them or stereotype suspects, you're dealing with people who don't have a great deal of education, and even though they may have exposure to the system, don't have a great grasp of the nuances of the system. Ask yourself, even after numerous classes here in this program and perhaps working in the legal profession, are there nuances of it that you just simply don't get still? Or with all of your knowledge, do you still feel like there's a vast amount that you don't know? Now take yourself out of the legal profession. Put yourself in a scenario where the only way that you absorb legal information is under the stress of an actual arrest or interrogation. It doesn't lend itself to being very knowledgeable about how to protect your own rights. So Miranda is important. The book mentions a couple other items about interrogation, that they can't be coercive. Coercion, in the classic sense, used to mean physical coercion. And then over the years, it has slowly incorporated things like denial of food, hydration, bathroom facilities, also threats of death, the death penalty being imposed. And then the book references on page 295 the Christian burial case. That case is very interesting because it was the first time that the court had recognized that there are really things beyond what we would consider standard coercion or duress. In that case, there was obviously a compulsion that the officer triggered by raising religious beliefs, and that ultimately was found to be an unlawful interrogation. A big component of these rights, pre and during and post-interrogation, is the right to remain silent. Defendant always has that right. They always have the right to invoke having an attorney present with them. So just because it's waived initially doesn't mean the person can't then go back and impose, request their rights that they were read initially. Beyond the actual interrogation itself, you then get into questions of a constitutional right to counsel, when you have that right, how you have that right. Those are sacrosanct. They're one of the most important protections in our Constitution. It is the right for you to have a third party to come in and represent you and safeguard your rights, knowing those nuances, somebody that has to be competent in the field. Of course, as a former criminal defense attorney, my recommendation to people is always have an attorney there with you. Have somebody who's trained and has your best interest at heart. Why go in, sit down across from an expert, i.e. a police investigator, and not have your own expert, your own professional beside you to try to countermand what they're going to do. Beyond that, Chapter 12 then gets into things like immunity, transactional immunity, use immunity. Those are all important items. Those two items take place typically after an indictment and an arraignment. The indictment itself is some sort of written document or accusation. It can be done in Florida through an information, or it can be done through a grand jury proceeding. Most states have moved to an information-based indictment, meaning the state attorney fills out a form and files it with the court. Parties then arraign. That arraignment is when the individual is brought before a judge, the charges are read against them from the indictment, and then they choose whether or not they will plead guilty, not guilty, or no contest. Keep in mind, no contest or nolo contendere is an optional plea that a judge can offer or not offer. It is not on the table in every courtroom. It doesn't have a lot of impact as far as pleading no contest, but there are some differences under the law, especially on the appeal side, whether somebody pled guilty or no contest. Oftentimes, defendants just want that peace of mind of not admitting guilt. A no contest plea is also referred to as a plea of convenience. I'm not saying I'm guilty, I'm not saying I'm not, I'm just saying that it's in my best interest to get rid of this case. I referenced immunity earlier. Transactional and use immunity don't get used a whole lot, but they do on larger cases. And the idea of it is transactional immunity is going to cover a specific series of events. It's the broadest form. So anything that's happening as a part of that case, and oftentimes anything that happens surrounding that case, are going to be protected by transactional immunity, whereas use immunity is going to be limited in scope. So beyond that, take a look at the privileges in Chapter 12. I think they're important to get to know: the spousal privilege, priest-penitent privilege, patient-counselor privilege. Those privileges are going to vary by state, not the protections, but what relationships are protected. For instance, some states recognize a reporter informant privilege. Some states do not. Some states recognize mental health counselors as privileged. Others do not. It depends on their classification. All of that stuff is going to be state by state specifically. Last but not least is this idea of an Alford plea. The Alford plea is something that isn't used commonly, but it is used on an occasion in order to facilitate appeals. So an Alford plea is where somebody in front of the court openly admits that they are only entering a plea, let's try that again. They openly admit in front of the court that they are maintaining their innocence, and that they're entering a plea in order to resolve the case for some sort of post-conviction purposes, i.e. an appeal. Like I said, they're not rare, but they're fairly unusual. You're usually going to see them in high-profile type cases or cases that have significant charges attached to them. I think the book references the Duke rape case, and that is one of those examples where that happened. So, as you go through the chapter, just keep in mind that the steps that the police have to take, there's no doubt that they hinder police investigations. They limit them. But they limit them in order to get the benefit of protecting those people who are most susceptible to abuse, and those are people that are being investigated by the police. All right, I hope that was helpful, and if you have any questions, don't hesitate to email me. Have a good week.